Under Armour had two sets of claims against it, while the sports authorities' forecasts changed. And they got sued in 2016, and then the SEC pursued them in 2017 to 19. And the question is, are those two claims interrelated wrongful acts? And I represent large companies who are always defendants. And I represent large companies who are always defendants who, when they have a coverage case, want to act like a defendant. And I'll look at this Fourth Circuit result and think, I wish this wasn't the result. Because what the Fourth Circuit did was it took the 2017 shareholder tower of $100 million and the 2016 shareholder tower of $100 million and the 2017 tower available for the SEC investigation and said, one tower applies because the claims were interrelated. Now, when you go and you look at the Fourth Circuit's analysis, I have the impression that the lawyering that was done, or at least the Fourth Circuit's treatment of the lawyering, was to treat it like a defendant. Because what did the court do? The court didn't use rules of interpretation that policyholders like about how you have to show that if you're going to turn $200 million in coverage into $100 million in coverage, you actually need to show that the language clearly requires it. They didn't use contra pro forentum, the favorite rule of construction of policyholders. And instead, they used dictionary definitions to show that logically and causally related is what happened here. And instead, and there's a footnote in the Fourth Circuit's opinion that says, to be fair, both parties cite lots of cases they insist support their positions. In reality, the cases are very fact-specific, and none are on all fours. Most have parts that help and hurt both sides. So you look at that. So what happened, in my mind's eye, what am I thinking happened in the Fourth Circuit? This was a case where one party put a stack of cases down, and another party put a stack of cases down, and they argued this on case law regarding what's frankly a very fact-specific issue. And those interrelated claims issues need to be treated like fact-specific issues and need to be litigated and tried that way, as opposed to permitting a court to, and I'll throw shade at the Fourth Circuit, permitting a court to simply weigh cases rather than get into the facts. Had the facts been litigated, maybe they would have been more prominent in the Fourth Circuit's opinion. Instead, we end up with a lawsuit resolved on the basis of a court trying to interpret cases that don't apply because that's what the parties put before them. And if you ask me, how do courts resolve cases? So what's your thoughts about jurisprudence? When you look at the Fourth Circuit's determination, like most cases, you'll see first legal doctrine, and second, maybe you'll see facts, and third, you'll see social context. You won't see social context, but social context is often behind the opinion. And what you'll see in the opinion are those things in that order. You see the legal doctrine first, maybe you'll see some facts, and often you don't see social context referenced at all. Frankly, if you ask me, most courts, when they're trying to determine things, come at it the other way. Even though their opinion will start with legal doctrine, they'll come at it with, at the appellate level anyway, what's the right answer? What's the right answer here? And what is the frame that we, as your plaintiff's lawyer in a coverage case, what's the right frame to put your claim in so that the judge starts to do this with your claim rather than doing this? And when you get the judge nodding with you, oh, the interrelated claims statement in the policy needs to be crystal clear before you can apply it to exclude coverage. That's not what the Fourth Circuit landed on. So this result is bad for policyholders, but it's something that I wish we had a chance to relitigate that again. And the chance of a coverage case getting to the Supreme Court's about zero. Next point, number 4, AI infrastructure suits. This hits me, A, because the numbers are absolutely mind-boggling. The last several years in talking about D&O insurance, one of my points, not this year, because it's no longer new, was AI. And why AI? Because there are all these things in AI, microprocessor speed, the amount of data in the world growing, the cost of training an AI model, all of those things are changing at an exponential rate. This graph shows the CapEx expenditure of the major hyperscalers, Meta, Google, and Amazon. That number is $600 billion. That number is half the GDP of Poland. It's, I think, the GDP of Sweden. I read in the paper today. I think Sweden has a $600 billion GDP. These companies are investing that level of CapEx. And surprise, in 2026, there are already a handful of AI infrastructure-related security suits, very early stages. One against Oracle regarding their increased CapEx expenditure on data centers. One against CoreWeave because there was some question about whether or not they could meet unprecedented demand for their cloud AI computing infrastructure. And one against the new nuclear power plant company that's dedicated to powering AI data centers. I predict that we'll see more. With a CapEx expenditure like the number we're seeing, you will see more of these because someone's going to make a mistake along the way, almost certainly. Another issue which was touched on earlier were issues in bankruptcy. One of the issues in bankruptcy that, on the one hand, is often easily resolved, but it still gets litigated. And historically, what's the insured versus insured exclusion? And there are cases that say this. The insured versus insured exclusion was originally designed to, because I see Anne nodding her head at me, I'm going to say, Anne and I are running a small company, and we're about to go bankrupt, and we don't want to gin up a claim where Anne sues me to bring insurance proceeds into the company to save us. That's what the insured versus insured exclusion was originally for, to prevent that type of fraudulent claim. And that's the frame you want to use with your court to get the court nodding at you about why is this in there? Why did it start? Maybe the language doesn't say quite that anymore because it's been permuted and changed over the years, but that's where it started. But in this case, the Avalone case in the Northern District of Illinois, a liquidating trustee in a bankruptcy brought a claim, and the court found that the insured versus insured exclusion applied to eliminate the claim. This is against most of the case law saying the opposite. And it's against the so-called ipso facto rule in bankruptcy, which and Diana will appreciate this, if Gene Anderson, our founder, were still alive and he heard me utter the words ipso facto, he would say, can I say this? Cut the crap. He would say that because stop speaking Latin, Bill, speak English. But what does that mean? Ipso facto means the very fact that. So what does that mean? It means if you have a contract which says by the very fact of your filing bankruptcy, you change the rights of the parties, that doesn't apply to the bankruptcy court. So here, and what does that mean? That means the insured versus insured exclusion wouldn't apply to a bankruptcy trustee because he's only there by reason of the bankruptcy filing. This court ignored that finding, and indeed, I think this was in a footnote as well, said that the trustee, the liquidating trustee, waived his argument that since the policy predated his appointment, that somehow it couldn't refer to him in the insured versus insured clause, which is very weird. If I were a betting person and I saw this go up on appeal, I like the liquidating trustee's chances on appeal. Here's another interesting case which I like because in addition to representing large corporate policyholders and large government bodies with insurance problems, we sometimes represent individual insureds or groups of insureds. And this Orion Health Corp case gives you another little tool. And that tool is if your D&O policy has an arbitration clause, but you're representing individuals and the arbitration clause doesn't say that the individual insureds agree to the arbitration, this court says it doesn't apply to them. Now that's an interesting thing to have happen if you're representing individual insureds in a D&O case.
You feel?
Yes.
Even if somewhere else in the policy it says the corporation can speak on behalf of, all the directors and officers, and so that agency wouldn't read that. That's interesting.
It's an interesting result. I don't know if the court addressed language like that, but it's an interesting result, and it's a tool that we may well come back to. But another thing happened in this case just 3 days ago. I finished these slides earlier than that. But just 3 days ago, in this same case, the district court found that, unlike the Under Armour case, that a prior acts exclusion did not apply, which is similar to the interrelated claims issue, and also found that a prior impending litigation exclusion did not apply because it found it ambiguous. So in that case, another, not this decision, but another decision in Orion Health Corp, a court reached favorable rulings on what I'll call gray issues in a coverage matter because it used rules of interpretation and the ambiguity doctrine in an insurance case.
I have a question.
Yes?
The arbitration clause defines the policyholder. Most clauses in the D&O policies that I've seen don't use the term policyholder, but use the term insured.
Oh, for sure.
And define insured to include the company and the individual insured.
That's a tick of writing that I'm guilty of. We try not to use the word insured, even though in D&O policies you have the corporate insured and you have the individual human insureds. In this policy, the definition, the arbitration clause spoke in terms of the corporate insured, but not in terms of the individual human insureds. And the court used that distinction to make the distinction it's making here.
I'm just curious because we don't usually see the word policy.
Correct. And frankly, mainly the reason we do that is because if you write insurer and insured, those terms get mixed up all the time, every day, and we just try to make them look different. So that's why we do that. That's an Anderson-Kill tick that I'm guilty of. Here's another case, relatively small but important, and I think this is probably going to go to the Delaware Supreme Court because this was a case alleging in the Brola versus Lundgren case involving a company called Credit Glory, where employees of Credit Glory had allegations against an officer for sexual harassment, and indeed pursued them with the EEOC and lawsuits in New York, and were successful in those claims and lawsuits, and then brought a breach of fiduciary, and then shareholders brought a breach of fiduciary duty count against the same officer for his breach of fiduciary duty for the same acts. Now, this issue has been litigated in Delaware before, and as a matter of fact, either 2 or 3 years ago in this conference, we talked about the McDonald's case, which was a similar fact pattern where the court permitted a breach of fiduciary duty case to proceed. And in the last couple days, there was a case by Vice Chancellor McCormick in EXP World Holdings, which in a 90-page opinion, I think 30 pages of that were devoted to the credit glory case, followed the McDonald's case and differed with the credit glory case. So I suspect, without knowing, that someone is aiming at going to the Delaware Supreme Court on whether or not, as a general matter, harassment claims can give rise to breach of fiduciary duty claims for Delaware corporations. But I think we'll find out. Another issue that came up this year is that the SEC had been tough on crypto, and now not so much. And so the world has changed. So among other things, what's happened? The SEC dismissed a case against Gemini's space station. They dropped the case involving Binance. They reduced a penalty for a company called Ripple Labs. And they dropped a lawsuit against the Winklevoss twins. And I'm a twin. And I wish I was in business with my brother, because then everyone would refer to me as the Passanante twins. But no such luck. But dropped the case there. And this is a perfect example of decreased regulatory scrutiny leading to decreased liability, probably leading to decreased insurance activity. You heard references to number 9, as you heard references to the bump-up exclusion. And I think this might have been the case that Jeroen was referring to, but it was not in the Fourth Circuit. But it's in Delaware, and essentially the Delaware court found that the bump-up exclusion did not apply. And if we go back again to thinking in ways other than is my case better than your case, because these cases go back and forth, turning on language in the policy. So what was the bump-up exclusion originally for? Well, the bump-up exclusion was to prevent, in this case, Samsung wanted to acquire a company called Harman and merged Harman into one of its subsidiaries. So Harman was the target, Samsung was the buyer. The insurance in this case was Harman's insurance, was Harman's shareholders who said, hey, you didn't get enough money in this transaction. The bump-up exclusion was originally designed to prevent Samsung from paying too little and then seeking from its insurance to get its failure to pay the increased compensation owed. So here, knowing what that history is, and we've seen this argument many times in many cases going both ways, but getting the judge to nod and understand, what was the bump up? That's a weird name for an exclusion. Why would you have that? Well, you have it to prevent someone from buying insurance to fund an acquisition that they pay too little for. That's what the bump up exclusion is for. And here, that's not this fact pattern. So this is a different fact pattern, and the court, whether it was nodding at that issue or not, instead goes into a two-part test involving legal doctrine. But in my view, how did you get the court to go into that two-part test showing, one, that the settlement amount represents inadequate consideration, because they didn't show that. The court found the bump-up exclusion did not apply. But rather than apply a two-part legal test, getting the court to understand what the purpose behind the bump-up exclusion gets you halfway there to start with. And now I'll end with something. I am not saying any of these allegations are true. And I like the title of this slide, the AI robotic pump washer, because this was it's an example of what happens when there's changes in technology, and this company, Rich Tech, was alleged by a short seller to have said, we're in a partnership with Microsoft. And then the short seller says, aha, that announcement of the partnership with Microsoft caused Rich Tech's stock to surge 40%. And then following, this is what the short seller alleges, following that surge in stock price on the heels of that announcement, Rich Tech announced a $38 million fundraise, so going off in fundraising on the basis of more expensive stock. But Hunter Brook Media, the short seller, went off and asked Microsoft, and they said, well, Rich Tech is just a customer, and we're not in partnership with Rich Tech. That's the allegation. So a securities lawsuit was filed. Nothing's been determined in the case, but that's a perfect example of, if you credit any of these allegations, someone would say, is an AI washing allegation. How do I boost my stock price? I do it by saying I'm doing something AI with a fancy AI tool. And then a short seller and securities class action plaintiffs come in and try to get to the bottom of it. So that's the last of my top 10. Now the recap is, which way do these things influence the market for insurance and liability? Well, class actions are down, so that's a down arrow. The disgorgement remedy with no showing of pecuniary harm, that's an up arrow. The interrelated acts precludes coverage under Under Armour, that's a down arrow, so less exposure. AI infrastructure suits, that's an up. The insured versus insured exclusion in bankruptcy precluded for trustee claims, that's a down. The arbitration clauses don't bind individuals, that's an up as far as I'm concerned. Harassment is not the breach of fiduciary duty, that's a down. The SEC has been tough on crypto, but isn't today, that's a down. The bump up gets bumped out, that's an up. And the AI robotic pump washer, that's an up. So that's the 2026 recap on D&O liability and insurance. I want to thank you all for joining us. The entire Anderson Kill team thanks you. And if you can, join us next door for a quick cocktail hour.